We acknowledge the Wurundjeri and Boonwurrung people of the Kulin Nation as custodians of the lands on which we gather this evening, who never ceded sovereignty of the lands on which we gather. We pay our respects to their elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples, and welcome our visitor to the University, Mr. Joseph Longo. My name is Peter Jopling. I'm the chair of the Menzies Foundation, and it is my great honour to welcome you all here this evening. The Menzies Foundation is focused on building capacity in the legal profession and providing the necessary tools, knowledge and skills to navigate and address current and future challenges, particularly those related to technological advancements such as artificial intelligence. The Ninian Stephen Law Program that we support, engaged in new legal thinking for emerging technologies, is an initiative in partnership with the Foundation and CADE, the Centre for Artificial Intelligence and Digital Ethics, codename CADE. This important work aims to position lawyers and the legal profession to effectively respond to the challenges of the artificial intelligence environment. Based on research and broad consultation through roundtables with the sector, the program will explore three key elements: practicing law with artificial intelligence, evolving law for artificial intelligence, and society and artificial intelligence, particularly in an ethical context in the world in which we live. Through this consultation, the program aspires to develop thought leadership, policy, training and practical education packages in Australia and, most importantly, in our Asia-Pacific region. The 2024 Ninian Stephen Oration, entitled Technology in the Professional Toolkit, honours a former chair of the Menzies Foundation and a very distinguished Australian, Sir Ninian Stephen, and will be delivered this evening by Joseph Longo, Chair of the Australian Securities and Investments Commission. The oration will explore the role of technology in the professional toolkit and how understanding and effective use of technology is becoming an essential, if not vital, part of the legal practitioner's skill set. Mr. Longo commenced as ASIC Chair, as you know, on the 1st of June 2021 and has had more than 38 years' experience in corporate law, financial services, governance and regulation here in Australia and abroad. He's been a senior advisor at Herbert Smith Freehills, specialising in regulatory matters, enforcement and commercial law, and before that, General Counsel for Deutsche Bank in London and Hong Kong for some 17 years. Joseph has experience navigating multi-jurisdictional investigations and enforcement activity and is a distinguished Australian. We're honoured and delighted that he will deliver this 2024 Ninian Stephen Oration, and I now invite him to speak to us.
Thanks for the introduction, Peter. Before I begin, I would also like to acknowledge the traditional owners and custodians of the land on which we meet today, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past, present and future. I extend that respect to Aboriginal and Torres Strait Islander people here this evening. Thank you for the opportunity to speak to you this evening on a subject very close to my heart. I commend the University of Melbourne, Centre for AI and Digital Ethics and the Ninian Law Program for their ongoing commitment to building the capability of the legal profession to respond to the challenges of rapid socio-technical change. Sir Ninian was known for his clarity of thinking and his extraordinarily wide-ranging interests. Over 40 years ago, as far back as 1983, addressing a seminar at the Australian National University, he said, "We must be skillful in our use of the electronic tools which the information revolution has given us." And how prescient was he? Sir Ninian was right. Let me elaborate. The more technology advances, the more human judgment can be seen as a defining feature of legal practice. You may have heard the view expressed that technological developments present a challenge to law and its practice. But I think the view that the legal system struggles to keep pace with the rapid, and it's usually assumed inevitably positive, developments in technology doesn't do justice to the dynamic ways in which lawyers have adapted to these changes. In essence, it's a matter of lawyers using and continuing to use critical human and intellectual skills, including in particular judgment, to adapt to new circumstances. In my view, technology is a necessary tool in a lawyer's toolkit, but it's not the only one. To put it in a nutshell, the more technology advances, the more it shows that lawyers are going to be with us for some time yet. And this evening, I'd like to explore what that means. So first, the relationship between law and technology. 20 years ago, a company called Napster, some of you may recall, argued that law can't keep up with technology while its users shared songs illegally. Then copyright infringement suits suggested otherwise. On the other hand, when law does step in, the argument is then made that law and regulation are preventing innovation. But given the changes we've all seen in our lifetimes, I think it's pretty clear that innovation still happens. I think if we look closely at the practice of law, we can see that law and technology have a long history of working together. As lawyers exercise judgment and employ critical thinking to adapt to technology's developments and advances. Let me give a few examples. I'll start with copyright law. The idea-expression distinction has accommodated a range of innovations, from the printing press to peer-to-peer networks, through to large language models or LLMs. Although software stretched copyright and copyright lawyers, for some time, eventually it was incorporated into the regime as a literary work. The rise of the open source movement, originally copyleft, was in part a philosophical response to monopolies granted by copyright law. But the open source innovation has thrived. Linux is an example of this. The success of the open source movement can be partly credited to creative copyright lawyers who had a strong grasp of the underlying technologies, developing innovative licensing regimes, such as the Creative Commons license. In recent times, we are seeing this play out with large language models. Both technologists and lawyers are grappling with questions such as, does training LLMs infringe copyright? Do the fair dealing defences apply? Are the works generated by LLMs protected by copyright? That is there sufficient sweat of the brow to receive protection? And so on. There are examples of people, lawyers, seeking to understand new technology and its ramifications, and they were using the skills we expect of lawyering in general: curiosity, open-mindedness, and most importantly, judgment. Another example of lawyers applying existing principles and skills in the realm of new technology might be found in anti-spam law and the concept of trespass to chattels. Now, I have to admit this stretched my knowledge of the history of torts, but you have to just bear with me. The invention of a fence around my property was, at the time, an evolution of technology. It also gave clarity to legal disputes. If you cross my fence, you've trespassed. But when you stand on the other side of my fence and scare my sheep, I go to a lawyer who makes a case that you are sort of trespassing. You're trespassing to chattels. A few centuries go by and the principle is applied to a new kind of property interference. That is, the concept of trespass to chattels, which applied originally as a charge against someone who didn't exactly trespass but messed with your livestock. This concept is later used in court cases against spammers. The argument is that the spammers aren't quite trespassing, just as a postman isn't trespassing when he or she comes to your door to deliver a parcel. But since they are clogging the servers, they are messing with your property. That is trespassing to chattels. This is not a story of law and technology. It's a story of lawyers and technology. So we can see lawyers can and do apply long-standing principles and employ critical thinking to help our understanding of new technological experiences. But is the opposite also true? Can technology contribute to the practice of lawyering? I think it's very clear that it can and that it does, and that that's accelerating as we speak. The speed and scale of the progress of technology in the law can easily be overlooked. Why? Because many of us take for granted the technology that was once innovative. I remember when I started as a lawyer in the early 80s, the most advanced technology in the firm was the telex machine. My firm had one. And believe it or not, we shared that infrastructure with other firms in the city. Then, of course, the mighty fax machine turned up and telexes disappeared virtually overnight. And then the now ubiquitous email arrived. Typewriters were rapidly overtaken by word processors, and all of a sudden documents became digital. And now we have the Australasian Legal Information Institute, or AUSLI. Most of us today couldn't imagine a world without it. Yet it was one of the first efforts to digitise and democratise legal resources. It spearheaded the adoption of medium-neutral citation protocols. This enabled the automation of content gathering and retrieval in a way not previously seen, certainly not in any free resource. And today, many legal practitioners and law enforcement agencies such as ASIC increasingly rely on technology-assisted review, or TAR, particularly in the e-discovery space. TAR processes such as deduplication of documents, email threading, or a find similar function are as groundbreaking as they are becoming increasingly necessary. With our ever-growing digital footprints, for lawyers to continue to maintain their duty to their client of due care and skill, it is arguable that they must turn to technological advances such as TAR. These are all examples of technology evolving and being adopted by lawyers to improve their practice of the law, and lawyers adapting to changing circumstances. But of course, while technology can very clearly be a benefit, like many things, it can also bring challenges. New technology brings with it risks that have to be managed, ethical considerations, confidentiality issues, and due diligence, to name but a few. As one lawyer in the United States infamously found out last year, using ChatGPT without independently verifying its findings can get you into hot water. Which brings me to artificial intelligence. We all see that AI is an astonishing development. The potential benefits to businesses and individuals are enormous, with an estimated additional $170 billion to $600 billion a year to Australia's GDP by 2030. And AI can bring both challenges and opportunities to lawyers. I'll start with the challenges. First off, let's be frank. Large language models can't think. They're language generators. But they do think, but they do not think as human beings usually understand the term. They can create extensive, comprehensible, even mostly accurate linguistic output, but they lack judgment. While LLMs can provide detailed answers about how certain ethical frameworks apply in respect of certain decisions, they are themselves without ethics. So while AI might assist in applying logic, it does not and cannot apply ethical judgment about which logic to follow or why. Nor can generative AI balance best interests of the client or employ critical thinking. For example, if you ask an LLM a question that assumes something untrue, it will take that assumption as true. A human being, on the other hand, may find, through research, that the assumption was false. This leads us to the much vaunted issue of AI hallucination. Recent research from Stanford University has shown that legal hallucinations are pervasive and disturbing. ranging from 69% to 88% in response to specific legal queries for state-of-the-art language models. Moreover, these models often lack self-awareness about their errors and tend to reinforce incorrect legal assumptions and beliefs. So, while an unscrupulous lawyer might conceivably try to deceive the court, he or she would do that in full knowledge that they'd made the case up. AI, on the other hand, thinks it's done its job well, simply because it has provided the answer to the question it was asked. As we've seen in the case of the lawyer in the United States, AI hallucinations can be a major risk for an individual lawyer's case, career and firm. But the irresponsible use of AI has a broader, more pervasive and potentially destructive challenge for legal practitioners. If stories of lawyers using and trusting AI legal hallucinations abound, public trust in the legal system and in the rule of law becomes eroded. As professionals, lawyers have a duty to the court, to their profession, to their client, and fundamentally to the rule of law itself. So AI can be harmful to lawyers and the legal profession when it is used without bringing to bear a healthy scepticism, a critical eye, and the exercise of judgment. But what are the opportunities that AI presents? Like the telex machine of old or the use of tar in e-discovery, can AI contribute positively to a lawyer's work? Well, according to Goldman Sachs research from last year, 44% of legal work can or will eventually be replaced by AI. A recent survey in Australia also showed a strong belief among Australian law firms that by 2028, AI will be doing at least some legal work. But before you rush to consider a career change, let's look a little closer. Joint research between Microsoft and the Tech Council of Australia suggests that only 10% of solicitor tasks could be fully automated. So there's hope for the lawyers out there. The rest would involve AI and human lawyers working together. That sounds more positive. So what kind of legal work can AI do? The most obvious is research and review. Again, provided there are sufficient checks and balances. In this case, just as a senior lawyer can't accept blindly whatever a junior gives them, neither should they blindly accept whatever comes out of their large language model of choice. Nevertheless, AI can be useful for lawyers in research. Another possible use might be in assisting with e-discovery, provided its findings aren't trusted implicitly. Interestingly, AI can also be used, to an extent, in the assessment of rights. For example, the self-styled AI consumer champion DoNotPay.com, a US-based, has to be in the US, a US-based online legal service and chatbot has helped individuals overturn more than 160,000 traffic offences. This might have interesting consequences for improving the decisions of regulators whose job it is to issue such tickets. If those regulators know that there are freely available tools which can readily check the validity of a ticket, it may be that less tickets would be issued which can be appealed. It should be clear by now that technology having an influence on the law is a given. But what that influence is depends on lawyers themselves, which brings me to my final point. It's clearly in lawyers' interests and in the interests of their clients for lawyers to stay tech smart. Indeed, some have suggested that legal thinking itself is already moving in this direction, with legal databases becoming more and more a key part of legal practice. It's argued that lawyers are beginning to think of the law as a collection of facts and principles that can be assembled, disassembled, and reassembled in a variety of ways for different purposes. This smacks of Thomas Carlyle's lament of some 200 years ago, that men are growing mechanical in head and heart as well as in hand. The point is that to the extent this mechanising of the legal mind is real, only to that extent will AI replace it. If, as I've shown, there's space for technology and lawyers to work together, this is not achieved through any kind of routine mechanical thinking. a machine will always beat a human at being mechanical, and so it should. No. The increased use of technology in law, lawyers need to employ some critical skills they've always used, to operate effectively in this environment. What are those critical skills? To reiterate, they are curiosity and willingness to learn, a healthy scepticism, and application of judgment. These are skills that mark out a good lawyer irrespective of any questions about technology. But they are needed more than ever now in our evolving technological environment. Much of what is routine, linear or mechanical can and will be replaced by something that excels in the routine, in the linear, in the mechanical. In fact, evidence suggests that LLMs are more efficient and effective at compiling lists of relevant cases than junior lawyers. But as I've said, mechanical research must be tempered by real-world fact-checking. Ultimately, as AI advances to equal human prediction and analysis, it only highlights the greater need for that uniquely human skill, judgment. When Stephen Schwartz effectively outsourced his research to ChatGPT in Marta v. Avianca, he was exhibiting an open mind about the potential benefits of AI, and that's good. But he failed to display a healthy curiosity about it. That meant he didn't fully understand it and treated it like a search engine, not a generative language model. He also failed to show a healthy scepticism that would have led him to cross-checking the AI's output. So, wouldn't it be safer for lawyers to reject technological developments such as AI? I think not. Lawyers today clearly need a level of technical proficiency. In fact, some have argued failing to take advantage of technology could be considered unethical, even malpractice, because technology-assisted legal practice can yield substantively better legal results. As far back as 2018, it was being suggested by an Australian academic, Dr. Michael McNamara from Flinders University, that the evolution of technology should be welcomed as a natural evolution and innovation in the delivery of legal services, just like the emergence of the modern solicitor and barrister, rather than as a cause for concern. Without a wave of legally and technologically literate graduates who either join existing law firms with fresh ideas, compete with legal practitioners by operating outside the purview of legal practice, or completely disrupt legal services with innovation, the legal profession risks stagnating. In essence, the legal profession's interaction with emerging technologies should be proactive, strategic, and bold. Lawyers need to be able to use technology, including AI, in order to actually do their job and discharge their duties. And they must have a level of data capability, the expertise to find, analyse, understand, and utilise data. Now, you might be wondering how this aligns with what I've said to market participants on other occasions about the dangers of rushing into innovations such as AI. My response to that is, our warnings have always been grounded in the risks of what happens when there is a lack of appropriate controls or proper governance. And lawyers have always played a key role in governance. And so effective supervision and oversight are critical to ensure technology is used responsibly. By being proactive, strategic and bold in their interaction with technology, lawyers can solve problems, not just identify risks. In conclusion, we must be careful with generative AI, but not be afraid of it. Technology has, in one form or other, always been here, and the history of law is very often in lockstep with the history of technological development. Sometimes that means the law helps shape our understanding and experience of technology. Other times, it's technology that's changing the legal profession. In any case, with the ever-increasing use of technology in law, being a lawyer means understanding those changes. Just as the public expects ASIC to be a bold regulator, I believe it also expects the legal profession to be bold in the face of technological advances, particularly if those advances could eventually offer greater democratisation of access to justice. At the end of the day, this means all of us in the legal profession asking the right questions to make sure we understand the benefits and, yes, the harms too. Above all, in a world of AI and big data, being a lawyer means having a range of tools in your toolkit. So while technology is very much a necessary tool in that toolkit, being a lawyer also requires responsible oversight of that technology, and it requires, now more than ever, cultivating an open-minded curiosity, a willingness to learn, and a persistent scepticism. In a word, it requires judgment. Thank you.
Yes, that's on. Well, thank you very much for that speech. I was pleased to see a celebration of the traditional characteristics for which lawyers have aspired: judgment, curiosity, belief, energy. And actually an optimistic...
I remember mentioning
it was implicit with all these things we're going to do. And I think actually an optimistic view of the role of technology in society, a refreshingly optimistic view of the role of technology that's not taking the jobs of lawyers, but perhaps working with lawyers used in a judicious way with judgment. So thank you very much, Joe. I'm Jeannie Patterson. I'm the Director of the Centre for AI and Digital Ethics, and leading this project, the Ninian Stevens Law Program, New Legal Thinking for Emerging Technologies, so kindly funded by the Menzies Foundation. And I get to ask the first questions, but then Joe has kindly agreed to answer some questions from our audience as well. So I will begin. Now, in your talk, you talked about the dynamic, energetic ways in which lawyers adapt law to changes in technology and the important role of judgment in doing that. And in fact, one of the things technology does is challenge us to think about law, the boundaries of law, the opportunities of law. Now, colleagues of mine recently completed a survey that suggested lawyers feel very anxious about this challenge of adapting law to new technologies. And lawyers study law for 4 years or 5 years or more years, and that study is supposed to give them the grounding for going out into the profession and meeting these challenges. I guess my first question to you is, should law schools or the legal curriculum or the dreaded Priestley 11 be teaching something like tech literacy, socio-technical literacy, or just plain old AI ethics as part of legal education?
Well, thanks for that great question. I have a small confession to make. I've undertaken a personal journey on this point, and I think I count myself among the alleged majority of lawyers who are fearful of technology or don't quite know what to do with it. But over the last 20 years or so, I've been very fortunate to work in a range of people who've opened my eyes to the need to take technology a lot more seriously, certainly as seriously as knowing all the latest High Court cases. And of course, most lawyers traditionally, we celebrate that. We celebrate legal expertise and knowledge, and so we should. That's a very significant part of the lawyer's toolkit. But what I've come to believe quite passionately now is that lawyers these days need to be able to navigate a society and a community now that's essentially digitised. And so to answer your question, I think that's got to start in law school. And I had the pleasure of meeting someone just before this evening who's who wants to study law, and I was very impressed. This young man is studying classics and physics, and I thought to myself, that's the spirit. We need to encourage people with that kind of intellectual breadth. We need great lawyers, but we need lawyers who are able to navigate this digital and technological world and not be fearful of a lot of the jargon and a lot of the technology. I think that's something that has to start in law school, and something we can talk a bit more about. Yeah.
So I'm going to a follow-up question, as you've almost invited me to follow up. Joe, you commented that by being proactive, strategic and bold in the interaction with their technology, lawyers can solve problems, not just identify risks.
That's right.
And this is a continuation of that concern that lawyers are fearful of technology and perhaps take too risk-averse approach when they're thinking about the role of technology, as opposed to perhaps thinking about its advantages, or even looking more widely at the implications of technology in society. Now, we might talk about some of that in the law school and legal education, but how do we infuse that throughout the profession? Is it CPD points? Is it something else?
Well, I don't think lawyers have much of a choice if they want to be fully engaged in what's happening in the community. There isn't a single business or activity that goes on in our society where systems, processes, technology isn't part of the delivery of whatever it is we're talking about. So when someone comes into your home to fix your fridge or to do some work, or you go for legal advice, all those people, they're using data. The successful tradies, what are they doing? It's all on their phone. They're very good at what they do. So the analogy with lawyer, they may be a very good lawyer, but they also know how to engage with the technology. And a lot of major businesses and institutions, a lot of the issues facing those institutions require some knowledge of this subject. You just cannot get away from it. And so I think that's why I really want to encourage curiosity in particular, and scepticism, because if you bring that to whatever issue or place you're working, then you'll be fine. Yeah.
I'm going to ask you a little wildcard follow-up question on that point. This is the Science Museum. It's an absolute beautiful space in this building. This building is called Melbourne Connect. Melbourne Connect is the site of the Faculty of Engineering Information Technology and the core of AI at Melbourne University. What about the engineers? Should we also be bringing the engineers into this conversation?
Well, yes. I think not just engineers, anyone with a science background. I mean, on other occasions, I get asked questions about the composition of boards, and I think we have, in fairness, an over-representation of lawyers and people with economic backgrounds and accounting backgrounds. And I hasten to say we need all those backgrounds on boards. But I think my fundamental thesis is that we need to be a lot more open and respectful and welcoming of the sciences in regulators, in businesses. And that means, I think there is a social thing happening here where people get scared of maths or scared. I know I went through this. And somehow we have to develop a community attitude that if we expect consumers and investors and people to participate confidently in our community, then they've got to be able to navigate these technologies. And if they're not confident in navigating these technologies, then they become what we call a vulnerable consumer. So the stakes are pretty high. The
stakes are high. Yeah. And in fact, I've heard it said we're all vulnerable in the digital age.
Yeah, that's right. That's exactly right. And as you know, there's been some excellent work done by a range of people that when you're online, sort of the deception by design thesis, I think there's a fantastic talk last year by a visiting US academic. So the stakes are high. It's not just about getting the right legal answer. I think there are lots of circumstances where having the technical literacy matters. Now, there are new areas of, we haven't got to sort of digital assets yet, or electronic commerce or tokenization, all of those things. But that's happening right now. So if you're a lawyer, you need to understand these concepts because a lot of your clients are taking advantage of them to be able to stay in business competitively. Yeah.
And there's a role there for the university, and there's role there for the Faculty of Engineering.
Yeah, and not just engineers. And historically, there's been some tension.
They heard you.
Yeah, we need to overcome that history. We need to develop a comity between the engineers and the lawyers, and I would broaden that to all scientists.
And I'd be saying, and our philosophers. All right, so you've talked about the relationship of lawyers, practicing lawyers with technology and the need for lawyers to engage and skill up and the role of the law school in doing that, but in fact you're talking about a broader project. You've talked about the need for market participants, on the other hand, not to rush into innovation. What does innovation mean for the regulator? Is there a duty for regulators to innovate?
The first point to make is we're not anti-innovation. Okay, I sort of allude to it in my remarks. The brutal reality is that once you start regulating something or putting some prescription around it, someone's going to say, "Well, that's slowing me down. That's having a chilling effect on my innovative energy and instincts." And sometimes that's intentional, because depending on what it is we're talking about, that may be in the public interest. We may want to regulate face recognition technology. We don't want that widely used, I don't think. We may have, some of us might have some scepticism about crypto assets, for example. So we may not want to prohibit their distribution, but we may want to regulate their distribution. And some people might see that as anti-innovation, but I think that generally speaking, regulation should be technology neutral. Now, in terms of the wholesale markets, I gave a talk about that last year. That's a whole other subject, but essentially, a lot of the markets are run by very complex algorithms, trading algorithms by whatever name called, and they do a lot of good work. Otherwise, you wouldn't have efficient markets. But when things go wrong in the market, you can't say, "Oh, the algorithm did it." So you've got to be able to explain how your algorithm worked and what went wrong, and that's the human loop part of it. And I think the humans have to still be in control, one way or the other.
Okay, I would agree thoroughly with that. What about the regulator, though? What are the regulators'
We're
response?
embracing AI. we're trying to figure it out first.
Okay. Are you using it? I mean, the regulator, any regulator has a pool of incredibly talented young lawyers who are doing their role. How does the regulator innovate with technology?
Well, as far as ASIC's concerned, there are a number of challenges, obviously. The first one is we are great data gatherers. So we're sucking up data from Australian Financial Complaints Authority, from internal dispute resolution schemes, EDR schemes, reportable situations. So we've got something called a data lake. So it's all that data there, and the critical question is, what are we doing with that data? And I think AI and the technologies that we are alluding to when we talk about AI help us draw inferences and conclusions from that data and help inform enforcement and regulatory decisions. And I think that's quite powerful, and we're doing that now. I think the other thing about AI and the regulators, and I think I've touched on this already, is that it's obviously evolving very, very quickly. So we've got a number of pieces of work going on trying to figure out how the entities we regulate are using AI. And a very good example of that are the banks, right? So the banks are great users of technology and systems and processes. They've got to get a grip on this subject. Otherwise, there are competition issues and there are massive opportunities for service to their customers. So that's another piece of work we're doing, trying to find out what our regulated entities are doing. The third area of AI, and this goes to your innovation question, is the current legal arrangements sufficient? And I've made some public remarks about that. I think a lot of our existing law has a lot to say about AI. So a very good example, I think Andrew has written about this. I think he's here somewhere. And goes to directors' duties. I mean, you can't be a director of a major institution in Australia and say, we're not that interested in AI. We're not interested in technology. So I think the existing law, a director exercising due care and diligence, a sort of absolutely fundamental duty, would be not discharging that duty if they weren't, as a board or individually, exercising actually the sorts of things that I want lawyers to do: be curious, sceptical, and a willingness to learn. So I think we're all on a bit of a journey here. There's a lot of hype around AI. I think, and you can easily find examples of people think it's going to be the end of the world within 25 years. We're going to lose control of this technology, and it's going to be an existential risk to the human race, worse than climate change. And there's a body of literature that says that, by the way. And then there's another body of literature that's a lot more hopeful and optimistic and says, AI will be fine. Well, it'll be integrated into our lives, and life will go on. But we're at the early stages, I think.
Well, there's a theme in everything you've said about the need to embrace it and make the choice.